Hi, it's John Leonard. I'm a corporate lawyer with Fairfield and Woods in Denver, Colorado. We have a series of informational videos you can get on our website and see. A lot of them are related to business issues, business and the law, although we have video presentations on litigation. We just wrapped one up with one of my colleagues on wills and trusts. It's very interesting. Today we're with Mark Smith, one of my expert colleagues on intellectual property. And Mark, thanks for joining us today.
Good to be here.
You and I talk about intellectual property. What is IP? When we say intellectual property, what is it?
It's what the human mind creates and its resulting product. It could be a book, it could be a movie, it could be a dance choreography, it could be a trademark, it could be a patentable issue. There are various types of IP, and the IP law has separate areas of focus and different means of protection.
And so today we're going to talk about copyrights and patents and trademarks and trade secrets, and then aspects of the law, anything from artificial intelligence to other things. So we're just kind of a potpourri of intellectual property, but at the end of the day, it is property just like that coffee cup that you can protect and sell. And
it is an intangible that has a right attached to it. So the rights emanate from either common law or statutory rights.
And when you say that, when you say common law, after creation, it's like manna from heaven. It's just protected under the law, whereas some things you might have to register to protect.
That's correct.
Protect in a different way, I guess. I don't know.
Well, the registration process applicable for patents, copyrights, and trademarks really are an extra layer of protection over what already exists in the way of common law rights. So you have rights upon the creation in a copyright. Once that representation or expression of an idea is made, there are copyright interests attached already at that point. You then may have to register it. Similarly, in a patent, you as the inventor have certain rights as an inventor, and the fact that it's patented gives you those rights as enforceable rights. In a trademark sense, you have a trademark right upon first use. So you don't need to do anything at the registration level, but it also gives you additional rights.
Well, let me just ask you some specific questions. Give me a couple of examples of what a trademark is.
Trademark is a brand, but it can also be a phrase, a catchphrase. It can be a logo. It can be a smell. It can be a color. It can be a sound. And in certain circumstances, it can be even a gesture by a famous individual. That can be a trademark.
Well, what's the difference between a trademark and a copyright?
Trademark protects a symbol and the channels of communication with the marketplace. And it is there to prevent confusion. Copyright protects the expression only of an idea. It cannot protect an idea. So your copyright protects the way you write an email or the way you write a book or a contract. It is merely the expression that is being protected, not the underlying ideas.
How do you protect an idea?
Idea has to be protected by patents, trade secrets, or contracts.
And so when we talk about intellectual property, somebody would come to you to help sort out what they have and then the best means to protect that so that you could commercialize them or keep them private to your own company or whatever. And so if you're a creative individual or a corporation that has these different brands or expressions of ideas that you've written down that you want to commercialize, you would be the person they go to help sort out which of these, and that they're not, they don't have to be, things can be more than one of one part of IP. I'm not really saying that very well, but you're the one that helps sort it all out.
Right. I do on a daily basis the analysis of what it is that's there and what areas of IP law are applicable.
Right. So we're going to delve into other areas of intellectual property, but the takeaway from this tape is that there are trade secrets, patents, trademarks, and copyrights. And if you have an idea or an expression of the idea, they may fit into one or more of those categories. Somebody like Mark can help you sort those out and get those properly protected and transferred, you inventors, you software guys, to your companies, so that when we get them financed and the investors want to know, does the company own its IP? You can say, yes, I've worked with Mark, and we've already covered all that. So we'll work into some of these, specific areas in other videos that we're going to do right now. Thanks for joining us.